Hello, everyone.
See what they're doing.
Hi. Can I get your attention, please?
But I'm sure I will.
I know the food line is still long, but I think we should begin. Welcome, everyone. My name is Dana Moon, and I'm the president of APALSA. On behalf of the whole e-board, we thank you for coming here today. And also, we would like to thank IU Asian Culture Center, LASA, BALSA, and APABA of Indiana for co-sponsoring this event. At this panel, APALSA hopes to provide a forum for an intellectual conversation from our community discussing the currently pending case, Students for Fair Admissions v. Harvard. Today, we'll not only discuss the for and against arguments, but also its impact on affirmative action in education in general. Without further ado, I would like to introduce the three panelists. First, Honorable Judge Jose Rodriguez. Judge Rodriguez was appointed to the Circuit Court of the 11th Judicial Circuit in Florida by Governor Jeb Bush in the year 2000. Judge Rodriguez attended Indiana University Maurer School of Law, where he has returned to teach courtroom procedure as an adjunct professor, and he's currently serving on the Alumni Board as well as LASA Alumni Board. Judge Rodriguez is also a published author. His works include A Florida Civil Procedure, Cases and Materials, and two practice treatises, Florida Civil Procedure and Florida Evidence. Second, Dean Frank Motley. Dean Motley first joined the law school in 1977 after working at Columbia and Amherst colleges. He's a graduate of Columbia College and Columbia Law School. Dean Motley has worked at three other law schools, Western New England, Florida A&M, and the University of Kentucky, the Law School Admissions Council, and was an Associate Vice President for Academic Support in the Office of Diversity, Equity, and Multicultural Affairs at Indiana University. Before he retired from the law school in 2015 as Dean for Admissions, he admitted nearly 5,000 students, more than half of Indiana Law's living alumni base. Our third panelist, Ms. Susan Shan, has an emergency currently, and she's on her way here. She'll be joined a little later. But we have Professor Karina Wang. She is our Maurer's clinical professor of law. And Professor Wang joined the Indiana Law faculty in 2006 to coordinate the Disability Law Clinic, which assists clients with Social Security and Medicaid disability benefits. She previously has taught at Boston College Law School and Florida Coastal School of Law. In addition, she has practiced poverty law with the Legal Aid Society of New York and Greater Boston Legal Services. Finally, I would like to introduce today's moderator, Professor Steve Sanders. Professor Sanders teaches constitutional law, family law, and constitutional litigation. His scholarship focuses on questioning arising out of the 14th Amendment's guarantees of equal protection and due process, with a special focus on issues affecting LGBT persons and same-sex couples. In addition to his scholarship and teaching, Professor Sanders has participated in groundbreaking litigation, co-sponsoring an amicus brief to the U.S. Supreme Court in Obergefell v. Hodges in 2015, which established nationwide marriage equality for gays and lesbians. Please welcome the remarkable three panelists and moderator.
Thank you. I think it's a great credit to APALSA to have conceived this program, to have sponsored this program in conjunction with a number of other student organizations and with the law school. What I'm going to do is spend maybe just 5 minutes giving you a factual summary of the case that we're here to talk about and sort of why it has become controversial and what its connection is to affirmative action. And then I will moderate what I hope is an active discussion among our panelists about this case and some of its implications. So the plaintiffs in this case, called Students for Fair Admissions versus Harvard, allege that Harvard, in its undergraduate admissions process, systematically discriminates against Asian American applicants in violation of federal civil rights law. The case was the subject of a 3-week trial last fall. There were closing arguments last month, and it's pending decision by a federal district judge in Boston. In its admissions process, Harvard scores applicants on 5 categories: academic, extracurricular, athletic, personal, and overall. The plaintiffs in this case allege Harvard engages either in conscious or unconscious bias by systematically assigning Asian American applicants lower scores on personal qualities, even which means they may be denied admission even if they have higher academic metrics, such as GPA or ACT scores. For example, the plaintiff's data uncovered during discovery indicates that Asian American applicants were more likely than applicants from other races to be described as standard strong, meaning lacking special qualities that would warrant admission. They were sometimes said to be less courageous or less likable than other applicants. As Michael Lee, senior counsel at the Brennan Center, has written, the writing off of these students as non-distinctive, interchangeable kids smacks of racist stereotypes often used against Asians in this country. Harvard vehemently denies these characterizations, denies its admission process, has a systematic bias. The plaintiffs' lawyers have built their case largely on statistical studies, and at trial they did not present any witnesses, any students who actually believed they had been discriminated against. For a little bit of perspective, Asian Americans are about 5% of the U.S. population. In 2017, they accounted for about 22% of the students who were offered admission at Harvard. So far, it may not be clear why this case is being talked about on the same panel as affirmative action. That becomes clear when you learn that the case was conceived, funded, and driven by an organization which is ideologically committed to ending affirmative action and has openly said it sees this case as a vehicle for getting to the Supreme Court to do so. The public face of the litigation has become someone named Edward Blum, a white 66-year-old legal strategist. He leads an organization called the Project on Fair Representation, which exists to, quote, support litigation that challenges racial and ethnic classifications and preferences in state and federal courts. Blum also worked with Abigail Fisher, who was the plaintiff in a previous case involving the University of Texas, which challenged affirmative action. As the website Vox puts it, they have a really good explainer about this case. Blum's open desire to end any consideration of race or ethnicity in college admissions has led his critics to argue that he is simply using Asian Americans as a prop to stir up doubts and resentments and added controversy around affirmative action. In its most blunt form, the narrative is that as a result of affirmative action, academically more deserving Asian American applicants are losing out to perhaps less academically well-qualified students in the name of promoting racial and ethnic diversity. Now, Harvard, for its part, emphasizes that promoting racial and ethnic diversity in building an admissions class is something federal law allows. Under federal civil rights law, private schools like Harvard fall under the same standard as the constitutional rule for public universities that the court provided in Grutter versus Bollinger in 2003. That rule is that race and ethnicity may be considered in the admissions process not as a matter of social justice or promoting racial equality generally, but to the extent that it helps a school obtain what the court has called the educational benefits that flow from having a diverse student body. These benefits include promoting cross-racial understanding, breaking down racial stereotypes, promoting better learning outcomes, and preparing students for an increasingly diverse workforce and society, all of which the court in Grutter found were advanced by, in that case, the University of Michigan Law School's affirmative action policy. So in other words, any consideration of a student's race in the admissions process must be tied to the institution's educational goals. The consideration of race may not be mechanical or based on a quota. Rather, it must be based on a balanced, holistic review of all of the academic, extracurricular, and personal characteristics that an applicant might bring. That's the law in this area. On this understanding, merit is about more than GPA and test scores. The Supreme Court has said it's all right to think about it that way. It is about all the ways that a particular student might contribute or might not contribute to the kind of class that the school wants to build. And finally, if this case does get to the Supreme Court, we can wonder, will the court continue to stand by that principle, or will this case change the legal and the social consensus about affirmative action that exists right now? So what I'd like to do, I was privileged that the students had asked me to moderate this, is to sort of call on the panelists in turn for some initial thoughts and then try to have a discussion. And let me say, they've given me their permission that if you have like a question, we want to save time at the end for questions. If you have something that someone says that you really don't understand what they mean, it's sort of a point of clarification, feel free to raise your hand, but we do want to try to save questions until the end. So what I'd like to do is start by asking Dean Motley, as somebody who has admitted so many thousands of students, including for a long time under this standard that has been in place now for about 15 years of holistic review, where race and ethnicity can be considered along with academic credentials and other things. Frank, at the law school, in your experience, how does that process work? How do race and ethnicity and athletic ability and extracurriculars and grades all result in assembling a particular kind of class?
Well, I'm old enough and been around long enough. I remember before U.S. News and World Report. And before U.S. News and World Report, we truly looked at the holistic aspect of that candidate. We looked at their undergraduate activities, their grades, the letters of recommendation, and sort of an afterthought in some regards, we look at the LSAT. Now, that was not the driver that it is now. Nowadays, the U.S. News and World Report is very important for schools for various reasons. So most universities, most law schools do pay a certain amount of attention to that. So in order to maximize your LSAT and GPA, or your SAT and GPA, Harvard and other schools will first look at a statistical, you want to get at least a half plus one of their class on the numbers. That is, if you want to have a 170 LSAT or 170 SAT, 170 SAT, you'll try to admit, at least if in Harvard's case, and I guess these numbers are important, about 1,600 students. So you want to have 801 or 802 that have the maximum highest LSAT and GPA. So there's a statistical part that you try to maximize. Now, Harvard has 1,600 students in the first year class. They get every year approximately 5,000 who have a perfect SAT. So they could admit there are 1,600 students, and they can pick among 5,000 who have perfect SAT scores. They can pick among 8,000 that have perfect GPAs. So if Harvard wanted to have a perfect SAT and a perfect GPA, they could do that. But then there would be, in any particular year, they get between 35 and 40,000 applications. I'll repeat that. 35 and 40,000 applications
just to
per
be clear,
year.
that's your experiences in the law school context. This case is about undergraduate, but it's small enough that it's kind of comparable. You're talking about undergrad. Okay.
They get 35 to 40,000 applications, and they pick 1,600 for their first year class. They get 8,000 with perfect scores on the SAT, on the GPA, and perfect scores, and 5,000 on the SAT. And so they could pick among people who have perfect scores. That's not how Harvard chooses to go. They choose to get half their class on their numbers and the other half on other qualities. The case, as I understand it, is that choosing people on the other qualities, the second half of the class, so to speak, they go on other criteria. And in law school, you look much more at the grades. Because you're picking younger people who are not in the same maturity level, you might give, I think, undergrad schools in general, I don't know about Harvard in particular, but other graduate schools in general, look at more potential. The student may not have been as active or may involved, but they were younger and not as mature, so they may give a little more leeway than you might do in college. But at any rate, Harvard has decided that half their class, a little less than half their class, they're going to pick on other criteria. And when they look at that other criteria, whether it's how many sports that they were involved in, whether they played musical instruments, what we used to call talent sport, talent academic, talent extracurricular, talent writing. They look at all these students and they pick them for something other than the GPA and SAT. In that process, the Asian students are not being picked like everyone else. For some reason, this process of subjective selection results in Asian Americans not being picked at the same rate as other ethnic groups. And that is, I understand, is part of the challenge, saying that on the subjective factors, the Asian students are being discriminated against. And from my point of view, the issue is, what do you do with that? Is that in fact true? if they are choosing not to look at SAT scores and GPA for these group of students and looked at simply for the subjective criteria, and that results in Asian students not being picked at the same rate that other ethnic group students are being picked, what do you do about that? Now, what you can say is you pull back on some ethnic groups and select other ethnic groups. In order to accommodate for some people, you have to not let some people in. I'm not certain what I think what they're saying is because the system is flawed, you should get rid of this whole subjective criteria, admit people solely on the SAT. And that would transform, as I understand it, Harvard then would have to pick, everyone admitted to Harvard would have perfect scores, everyone admitted to Harvard would have perfect GPAs, because Harvard can do that. Most schools can't in the country, but Harvard could do that.
Frank, can I ask, again, at least in the law school context, why would that maybe not be a good idea? Why, again, do you want to look at other things like race and ethnicity, socioeconomic background, extracurricular talents? Would you have a different kind of class, and would this be a different law school if, just as would Harvard be a different undergraduate institution, if everyone was just based on picked on the basis of a perfect test score or GPA? What are
my
the
experience in the
benefits
law
of
school
educational
is
diversity?
that there are other factors other than simply SATs and GPAs. The SAT is a timed examination. You're asked like 100 questions, and how quickly you get those 100 questions right. If you're 3 seconds faster on average than someone else, you get a high SAT score, and that doesn't seem an appropriate basis for deciding who's going to be a lawyer for you. Grades, there's some schools where everybody in some schools and courses everybody gets A's, and some schools and courses it's very hard to get a C. So I'm not sure how reliable in terms of overall evaluation the SAT or the grades are. Letters of recommendation, I think, have importance. The quality of school has a great deal of importance. And more importantly, experience of faculty and alumni is that the students who had the best SATs and the best GPAs performed in the same general level as people who didn't have those high LSATs and high GPAs. And the qualities of what makes no one can predict who would become president of the United States from their class. So that the qualities in the real world are not a function of SATs and GPAs. I don't know what Shakespeare or Socrates' LSAT or GPA might be, but they did make contributions. So I think the experience is that people who have been successful have not been people who were, quote, had the highest SATs and GPAs. Now, on the alternative, there are some people who say, well, you haven't tried it. How about if you admitted a class totally on the SATs and LSATs? How do you know how bad it would be? I mean, smart people do other things. Smart people have other qualities. And so one argument might be that you should try it in that regard. Harvard, who could do it and has done it in some occasions and can compare to students who have come with high scores and low scores, has decided we as an institution don't want to be, and we could do it, we don't want to have people here who are only strong in SATs and GPAs.
Okay. Karina, let me ask you, so has this case divided Asian Americans? There is not uniformity of opinion, just as Asian Americans encompasses a very large set of people. Opinion about this case, which has been ostensibly brought on behalf of Asian American students, is divided. Is that correct? What's this case doing in the larger, what does it tell us, do you think, about the larger attitudes of the Asian American community, to the extent it's even possible to talk about that kind of construct?
Right. So the first disclaimer is that I am speaking only for myself and not as a representative of all the Asians and Asian Americans in the United States. That's a very, very diverse group, and that's, I think, in part the point that I'm asked to make. From the whole piece of implicit bias, in-group, out-group biases that exist, there has been a tendency in American history to think about Asians as East Asians first and primary because of how immigration patterns happen, and to then stereotype Asian Americans in sort of this subjective way of being less courageous, more standard academic, more stoic, very good at STEM and music, those kinds of things, without understanding structurally why some of those things happen. In a way, for me, this case is really exciting, not because I agree with the plaintiffs, and in fact I don't at all, but because it does show the maturation of the Asian American community here. that we are also diverse enough that, and big enough, that splits in ideology within this large geographic and racial pool are becoming more obvious outside the group. So it's harder, I think, for non-Asians in America to see the group as one monolith. And to date myself, there was Doonesbury in the old days, had a comic strip one time in which Honey, the Chinese interpreter for Duke the Ambassador to China, was speaking for him. And she says something about, don't worry, we have come only to, because we want computers for our young, right? That was why all the Chinese were moving into the United States. It had nothing to do with the change in immigration law or something. But we're all here for computers for young, and that fed into the stereotype. And so if you were going on some of those talent indicators and who can take the time and who is driven, why Asians who come into the United States at different times in their life were more driven on traditional academic factors, it's because of immigration laws. And it's the brain drain that started in 1965 when the immigration laws changed. The people who could get in were the ones who were here in some ways because the new people who could get in, not the ones who'd been here already for many, many generations. But the big influx was because brain drain. People who were here studying as graduate students could come here, and they were coming in part because there was that kind of American opportunity. So those parents passed on those specific family values and desires for different specific academic success, and that became part of the newer stereotype of Asian Americans. And then we had different waves of Asian immigrants coming in where you did not have the wealthy people and the highly educated people coming in, and so the group has become more diverse. On top of that, as we all get used to being here, as a child of immigrants, I'm an immigrant myself actually, but I basically grew up here, our values changed also. We still have some of our home country of origin and family of origin values, but there's differences. And so we have become very diverse politically, socially, socioeconomically, linguistically, all of that. So when we have a controversial issue like this, I'm really excited and pleased to see that there were Asian advocacy groups on both sides of the issue.
So you said you may not agree personally with the premises of this case that the plaintiffs have brought. Do you know Asian American young people who have said who think either they have benefited in some way from affirmative action or that affirmative action has hurt them because it means that other races, students from other races, other ethnicities, students with other kinds of characteristics might have been prioritized ahead of them, even if their academic credentials might have been stronger? Do you hear that from students?
Absolutely. I mean, I've heard it in my own family at times, too. I've probably been known to joke, I have been known to joke that I would not have gotten into my law school the way numbers are now. I was going to law school at a time when there were fewer Asians than there are now. And so I have no idea. I don't think that was the only reason I got in, but I think my scores were good, but they weren't the top scores on the LSAT as then score. So there is that feeling, and I think it's a myth if we were to be able to get the evidence, and that's partly what's been great about this case. We're getting to see how some of the schools really play out the different numbers, objective and other indicators. We are subject to the same myths that anybody else is about what it means to go to Harvard or to a school like Harvard and how one gets in. If people know of Amy Chua, she's a Yale law professor who is an Asian American. She is actually not directly from China herself. But 4 or 5 years ago, she wrote a book called The Battle Hymn of the Tiger Mom. I don't know if people have read it. The idea is essentially like that super helicopter parent Chinese parent, she was very specific that it was Chinese culture, who pushes her children solely towards traditional academic and music talent activities at the expense of everything else, because that is what you do to have your children succeed. She was reading this very narrowly. And the book is partly the struggle of her children to fight against and how much they accepted that. But there was a huge backlash around that. She was sort of buying into that and sort of laughing at that herself, that stereotype. But David Brooks, the right-of-center New York Times columnist, wrote an op-ed piece entitled "Amy Chua is a Wimp," which I absolutely love because it justifies how I'm trying to raise my kids when I'm not being a tiger mom. But the idea was that Amy Chua is a wimp because by not allowing her kids to go on overnights, not allowing her kids to be in school plays and so on, she was depriving them of an education they needed in many ways more than just the straight A's and the perfect SAT or LSAT scores.
Okay. And Judge, I want to ask you, I know you have feelings about the principle of affirmative action. So again, the sort of background of this case is the issues are interesting in and of themselves, but clearly the people who conceived this litigation see this as a way of raising more doubts and controversy about affirmative action and maybe getting the Supreme Court to change its mind about the current standards of affirmative action. Why would that be dangerous, or what is dangerous about that idea in your mind?
I do have my personal feelings on that. I alluded to them in the brunch upstairs that I may not, since we're being recorded and videotaped, I may not wish to share them with you, but you know what? That's never stopped me before. So, therefore, I will tell you how I feel about it. This man, first of all, I'm Cuban. I was not born in the United States. I'm not even first generation. I was born in Cuba. I came here when I was almost 9 years old. So therefore, the first generation in my family is my daughter. If this gentleman to my right had not admitted me in his first class, I wouldn't be sitting here today. And that was back in 1978. Therefore, I know I didn't get in just on merit. Doesn't matter who, you can't convince me of that I didn't just get. He's gonna tell me that I'm wrong, but that's okay. He can tell me anything he wants. Okay. I'm just not convinced at all that I got accepted to IU on merit. Not in 1978. This room to me is unbelievable. There were only total African Americans and Hispanics. I don't think there were more than 15 total in the law school. Therefore, that's when affirmative action basically started to set in and be applied. I do not have a problem with affirmative action. I'm a product of affirmative action. Doesn't matter what you tell me, I'm always going to believe that. Did I turn out okay? Depends on who you ask. I think I did okay. It was his foresight, Mali's foresight, by admitting me and my fellow classmates from Miami, as a matter of fact, that made us succeed in a world that was not really for us. Which you have to keep that in mind. The world was not really for us. There's always bias, prejudice, and other human frailties that keep you from doing that. We don't want, so therefore, I don't have a problem with numbers. Unfortunately, or fortunately, I have to follow the law, and the law says that equal protection applies to everybody, in this room and outside this room. Therefore, I believe, and I don't talk too much unless you get me going. I believe this move by the Asian students in Harvard is a way to, somebody mentioned it before, I think Professor Steen, a way to get it to the Supreme Court to terminate affirmative action. And we can't allow that to happen. And with the new Supreme Court, that may be a possibility. On the phone the other day, I assume you are Ms. Sham, okay? I asked, isn't it interesting that the Asian students are the ones that are bringing this lawsuit when they get accepted in higher ratios than Hispanics and African Americans? That is a very interesting point. That why the Asian students? Why the Asian? That's what you got to ask yourself. Why the Asian students? Do they have better qualifications? Absolutely. But do you think that as a whole of the United States that they will be agreeing with the Asian students that they're being discriminated against? Aside from over the whites, you think that's real? That's a real question. That it's actually true that the greater white student bodies would agree that they're being discriminated against over them, unless there was a hidden agenda somewhere. I'm just throwing it out there. Maybe not. Maybe it's just those questions that you need to ask. And keep in mind, and to further that, does it extend now to the professors at the law schools and the universities? Are they now going to not allow them to be diverse because some are better qualified than others? And it depends on the goal that you're seeking, and the university's goals are diversity, because we need to interact with each other. The United States is getting more and more diverse, although there's a movement towards ending that as well. Ask yourselves those questions.
Okay.
And I don't want to turn this into a political issue, but those questions need to be asked, and they need to be answered.
So we're joined by Susan. Susan Chan is a lawyer with Keitlinger and Gray in Indianapolis, and I want to make sure I get the name of is the Vice President of the Asian Pacific American Legal Association of Indiana.
Bar Association.
Okay, Bar Association of Indiana. So thank you for coming. I'm sorry for the problem that you had that delayed you, and it's great that we get 4 panelists and even more perspectives. So Susan, my sense is you have followed the Harvard litigation. I'm sure you've been in conversation with people who have different attitudes about it. Have you reached conclusions, I guess, about the merits of the case, of the arguments that have been made about conscious or unconscious bias, and to the extent that might exist, whether that should cast doubts on the enterprise of affirmative action more generally?
And I just want to start off by saying that I'm a huge supporter of diversity, and
you might just pull the microphone up so people can hear you. Yeah, thank you.
I'm a huge supporter of diversity, and I think it is very important in terms of our world and in law. And this is an issue that, of course, for me, I've gone through personally. It has touched me. But I think in terms of the merits of this case, number one, there is a huge issue with the fact that the plaintiffs have not brought a face plaintiff. And there's no one here who can say, look, I was discriminated against. Here are my scores. This is my resume.
The plaintiffs have remained anonymous, and no one was called to the stand.
Correct. You have a group of students, and so I think that's a huge issue because you don't have anything concrete to put forth. However, I think that, with this case, so much is relying on statistics and both sides. I mean, it's a battle of which expert is putting forth their methods of calculation. Something that I found very important and interesting was that, the average acceptance rate, and this is going from 1995, it was over a 20-year period starting from Harvard's class of 2000 and then going to 2007. And so the average acceptance rate overall over that time period was 9.3%. And Asian Americans were accepted at a rate of 8.1%. By comparison, white applicants saw an average acceptance rate of 11.1%. African Americans saw 13.2%, and Hispanics 10.6%. So you have Asians. This is data that, this is explicitly, they were the only racial group that was accepted under the average acceptance rate at Harvard. I think a lot of this issue goes toward, and a lot of people have made a big deal out of this personal score. And this is something that elite schools use because they want a holistic method of admissions, so they want to look at the total package. So you have an admissions officer who sits there, looks at everything you have put forth, and gives you a personal score. And it's one of, I think, 4 criteria that Harvard values. And this personal score looks at your ratings in terms of kindness, courage, leadership qualities. And how do you determine someone's kindness or courage based off of a paper? And that sounds crazy to me, but this is what they do. And I think that it was either a former dean of admissions at Cornell or Dartmouth who said that in terms of what they do is they have an admissions committee, and they actually meet to sort of go over what they're supposed to do to make sure that everyone's on the same page. And I mean, you're talking about someone you have never met, looking at a paper, things that you have put forth to try to give you a personal rating, to determine your personality. And that is supposed to have, and I don't know, obviously these, the admissions process is very secretive, and I don't know how much weight that has, but it is one of 4 factors or criteria, and of course standardized testing and your GPA would be other ones, extracurricular activities. Those are things that they look at. And so I think that this personal score, and it, of course, statistics have come out that Harvard gives lower personal scores to Asian Americans because for whatever reason. And, and I think that it's tough. I mean, being Asian, and I was born in China, I came here when I was 5, I kind of see both worlds of what the U.S. is toward what China was when I grew up. I had tiger parents, but I grew up, I love sports. I was not a typical Asian who just sat there and studied. But, I play piano, I play violin, like all these stereotypes. And I think it is very difficult to give someone a personality rating or a score because for me, and I can speak for, a lot of people I know, in the Asian culture, you are very innate and internal. You don't express your emotions as much. And it took me a very long time to sort of come out and to be more personable. I used to, in this world, in law, we have to network a lot. Networking is huge. And I used to hate networking. I mean, it was a job. And, I would put on a face and go out and do it because I had to, but I hated it. And I would go home and feel just exhausted every day because you're putting forth a part of yourself that you didn't, I think that if someone were to ask me, I would say that I'm definitely much more of an extrovert at heart, but because of, I think, jobs and, forcing us to be more extroverted, I have become that way, but I think that that's a big part of it. I mean, you're talking about Asian Americans or Asians in general. The culture is that you are much more internal. You don't express that much emotion. And I think that is a big issue in terms of this personal score rating because it's hard for us to put ourselves out there.
Susan, could I press you on just one thing? So you said a minute ago, Harvard gives Asian American students lower personal scores. I think you said for whatever reason. Well, the heart of the claim here is that this is actually either conscious or unconscious bias. Based on what you've said, based on what you've seen, based on your experience, would you say you believe that is more likely true than not true, that is operating here?
So I think that one of the things that obviously the plaintiffs are claiming is that admissions officers have an unconscious bias because they'll look at an Asian applicant and then have stereotypes, whatnot, and give them a personal score that is lower. Whether or not that's true, I don't know. But I will say that I think that maybe the heart of the issue is the fact that we have this personal rating and that admissions officers are looking at a piece of paper and giving a personality rating to a person they've never met before based on their resume, their extracurricular activities.
Assuming they're doing that, is the correction throughout the whole system, or is the correction to get better admissions officers more sensitive to the Asian American experience?
So actually Harvard had specifically put in their personal rating, I think it was beginning in 2013, it was a disclaimer, do not use race as a factor in giving your personal rating. I think that's very interesting. Why did they need to come forth and specifically put that out there? And I think that maybe internally they realized that there was an issue where admissions officers were unconsciously being biased against Asians and giving them lower personal ratings, that they felt that they had to do this.
Frank, in your experience as somebody who's read a lot of admissions files, do you think that is at least plausible, that there can be conscious or unconscious bias that operates not just even on the basis of particular ethnicities? Maybe certain people who read admissions files are biased, against rural students and in favor of urban students, or against students who are Democrats versus Republicans, or something like that. I mean, is that a danger that you have to look out for?
People, the faculty and students are all people, and they have biases, and they're unknown to themselves. And you discover it in the committee because sometimes you have conversations and you find this person's got this notion about work experience. The student who's been 4 years of college and never worked a day, that person has a little prejudice against them because they went to school and they worked, and this person didn't work. And there's a little bias. I mean, what is their work experience or not work? Maybe they had to work, they didn't have to work, or they couldn't get jobs, or whatever. It's irrelevant, and one might argue, to whether they're going to be a good law student. But this person has a prejudice in that regard. So I think people have those prejudices, and what you do is you bring it to their attention, and then they say, okay, let me meter that down a little bit, and you try to correct it. And that, I guess, is my interest, is that if there is a bias against Asians that the readers have, then how do you correct that? Now, either you say it's not correctable, you have to throw out the system, or you say you have to correct it. And you say the prophylactic of sitting up and saying, please don't use race negatively, doesn't work, then what you do training. Well, if training does work, it's the same thing we do with the police. The police, you say, don't violate their constitutions. And if they keep doing it, then you don't get rid of the police force, you get better police. You don't get rid of the system, you get better readers. And so I'm just curious about the lawsuit. The lawsuit says Harvard can't do this. They can put Miranda warnings on the thing, don't discriminate against Asians, but they're going to continue to do that. So in order to correct it, what you have to do is get rid of this whole system where you look at it subjectively.
Or don't stereotype Asians. Anyway, I think that's the specific claim here. Don't stereotype Asian Americans as opposed to...
Yeah, but if they don't do that, if they can't do that, if the prophylactic, if you say don't do it, they keep doing it, then I think the lawsuit says get rid of it.
So, Judge, I think you wanted to get in, and then I might ask Karina if she wants to say, I want to try to, I think we're going to plan to go till about 10 after 1, recognizing some of you might have to leave before that for classes, but want to try to leave about 15 minutes for questions, too. But Judge and then Karina.
You can do that for any minority. It just happens that the highest drop has been in the Asian students minority. You can do that for Hispanics. You can do that for African Americans. You can do that for everything. Maybe they're using bias against Hispanics. They use bias against African Americans, but it's not shown in the disparity. So I don't know how you fix that. You're right. I don't think you should throw out the system. I think you're correct. Maybe you should get better readers, better people on the committee. In my view, I got the same problem. I'm a human being, I think. Okay, it really depends on who you ask. You ask some of the lawyers and they don't think so. Okay, but I am a human being, so therefore I have biases, I have prejudices, but I have to be able to recognize those prejudices and biases and set them aside to do my job. Maybe that's what should be asked for in reviewing the applications and hiring the right people.
Carmina, is it your sense would we lose something if we couldn't take personal characteristics, however we're going to define those, into account in building a class here, building a class at Harvard?
Absolutely. I think Director Liz had brought in Tristan Murtha from ICE Mill. She's their diversity inclusion officer recently, and Ms. Murtha talked about how there are a number of social science research projects now that show that racially and otherwise diverse companies do better. They outperform groups that aren't. And Professor Henderson will talk about AT&T Star Labs. That is about the perspectives of people in your teams, in your communities, that will make a community richer. That would mean that the class of all 1,600 scores and 4.0s is potentially very boring. I would actually suggest somewhat humorously that if those Asians who are in fact low on some kind of valid score in certain personality traits would be the affirmative action candidates for a school that is diverse, because they, like Amy Chua's kids, need that exposure to different people and to the ability to be emotional and social and so on. we're forgetting as Franken is saying, you can have both the implicit bias and a different system, and not throughout affirmative action. Part of what I'm hearing is we need to be very transparent about what's on the personal scale and what the standards are for scoring people on that scale, and perhaps divorcing who judges the personal scale and what they see in a student's file from what is happening on the objective end, because it is impossible. There's a very recent implicit bias study in which attorneys at firms, and a diverse group of attorneys were given a memo, and for half of the group they were told that it was a white male attorney, and for the other half they were told it was an African American attorney. Exact same memo, exact same errors of punctuation, grammar, spelling, whatever it is. And all of the attorneys rated the memo from the allegedly African American lawyer as worse. We all have those biases, including people in the same group as the person who's being viewed. So you want to think about structural ways that can change it. Frank, you talked about like not throwing out the system, right? And when you talk about like the police, one of the things some communities have discovered is if you can divorce portions of the task, you get rid of some of the racial bias that happens. Like if you have a police officer doing a chase, pursuing a suspect, you don't have them be the person who arrests the suspect, because changing the person, getting away from the adrenaline rush of chasing a suspect, changes the reaction and the interaction of the arresting officer with the suspect. And so some of the racial and police violence dies down. So can we come up with a system like that?
Susan, since you joined us late, let me give you the last word and then see if we have questions from the audience.
I actually read about the same study in terms of giving the grammatical errors versus a white male and a black male, and essentially the white male scored higher. It was actually, I think that the people who were reading that would actually give good comments to the white male and give criticisms to the black male, where they were the exact same papers with the same errors. I thought that was very interesting. But, the University of Chicago was, I think, the first school that essentially got rid of mandatory disclosures of SAT scores, or SAT and ACT scores. So now, if you were to apply to Chicago, you don't have to give a standardized test score. They allow you to give a 2-minute video that introduces yourself and gives more of your personality. I thought that was really interesting. I mean, University of Chicago is a great academic school that the first of its kind that's gotten rid of looking at a standardized test score. It is not required. And, I think I thought about that, and I thought back to when I was in high school, how I would have liked that. And I don't know, because it goes back to, for me, I was much more of an internal person, and it was more difficult to show my personality like that. So for a high school junior, 2 minutes to do that, I think that in itself, then you think of all these other issues that come with it. Well, that would benefit the people who are more extroverted and can show something on video, or people who come across film better. And so I think that with each of these issues and whatever factors that you want to put forth, there are issues, there are implicit and explicit biases. Like I said, I'm a huge supporter of diversity. I don't think that we should get rid of affirmative action, but one thing that people have sort of put forth is for people to stop looking at race as a factor of affirmative action. You can sort of get through to the same racial diversity by giving more strength to something like socio-economic factors. And that way you take race out of it, and race stops becoming the issue. And I don't know what the right answer is. And I think that with any kind of proposal that you would put forth, it comes with its own issues. Okay. But I do think that it is clear, we're talking about battle statistics. It's out there. It's clear that statistically there is some kind of an issue here.
Okay, so let me, and I'm sorry we weren't able to reserve more time, but let's take till about 10 after 1. If you have to leave, that's understood. But questions, and something phrased as a question, please, not as a statement. Yeah, Erica.
Do you think it'd be possible there would ever be a legal challenge to legacy admissions?
Legacy admissions, meaning if your grandfather or your father went here, they get in. I don't know, Frank, do you want to take that one? Do you have thoughts about that?
Yeah, I think there'll be a challenge, but a legacy admission is revenue. Legacy is the ability to continue as an institution. Legacy admissions are your economic survival. I don't think that schools are going to be, I don't think the courts are going to then say, if you admit these 10 legacies, you will continue. We're not going to let you admit these 10 legacies. So I think they'll be challenged, but I mean, it's part of the revenue stream that your alumni will give, and you came here, and you want that to count a little bit. And there's probably, I think, personally, nothing wrong with it counting a little bit. It shouldn't be a Trump, no pun intended, but it should count a little bit.
Bill.
And I have to say something, and that is, and I mean this more broadly, but you can do things easy or you can do things hard. Easy is using LSAT and GPA to admit people. That's easy. And you don't have to hire people. You just you put the machine on, set the numbers, and admit people. That's easy. It's hard to go and read files and combine factors and admit some people in the SAT and some on the LSAT. That's hard work. And not only is it hard work, but you get criticized. Like juries get criticized. But it's probably better for the system that you use a combination than you just use one or the other. I would be opposed to video-only admissions because that's just personality. I would be opposed to numbers only. I think the combination is tough. It's hard. And it requires people to take a stand, to sit up, to look at other factors, to use their own experiences. But it's easier just to use the numbers. And when you get to your firms, you just use your GPA. Admit people from certain schools with certain GPAs and leave it at that. I think firms can, and some do it like that, but I think they miss a lot of good people.
Okay, we have a question here.
For the admissions process, when the example given from the study was talking about policemen separating, like one of them chasing one of them, arresting the person, in admissions, would it be, I don't know if it's already done like this, but one person or one group only looking at test scores and academics, and another person looking at, I guess, personality or the other things that we discussed, and then those two coming together? Is that already done? Do you think that would make a difference?
Every law school does it differently, but most of them will have a cutoff point. Everybody above this LSAT and everybody above this GPA gets reviewed by somebody. Unless they've attacked the president or got felonies, you admit them. And then they look at the other group, and they usually divide it up into committees. And they'll say, you read these 5 folders, you read these 10 folders, and some combination thereof. But you admit people on the numbers, about half the class, and then you admit the other people on subjective factors. And
I'll just chime in because this year I'm on the committee that is a group of faculty and students that reads that group kind of in the middle. And I wouldn't want to divorce that because, by definition, files come to us because the LSAT's a little low or the GPA's a little low, but do we see other things, persistence, first-generation student status, a lot of relevant work experience that make up for, if we're calling those personal characteristics that make up for, maybe not a perfect LSAT. So I think the whole idea behind holistic review is that you need to sort of be able to consider all of that. You can't separate out those threads.
Well, if you have to choose which faculty you put on the committee, and they all went to Ivy League schools, they all did straight A work, they should judge others. I mean, they're not peers of the people they're accepting. So, and the law students here have all been the same kind of thing. You do the best you can. You pick people, and you hope people are fair. You people who got straight A's understand students who got straight B's, and aren't saying, well, how dare he didn't work hard or she didn't work hard. So you work with you have, and at a law school you use the faculty, and you use. You don't ask me how many of y'all had C's in school. Therefore, y'all should judge more fairly than. So you use the best group of students, faculty you can get. Does that answer your question?
So other questions? Yeah, in the back.
Do you think instead of subjecting only half of a potentially admitted group to these personality tests and personality scores, instead of like separating it like that, if everybody was subjected to being looked at like grades, LSAT, or SAT, and then like letters of recommendation, would that solve these issues that potentially are facing the people that are on the lower half that are automatically admitted because of their grades?
I mean, I'm sure Frank has expertise, but only to give maybe the judge and Susan an opportunity to weigh in as well. Do you have thoughts about how that kind of system might work?
No, I don't. I have no experience in admissions. But what I would say about admissions is it's never going to be perfect. I mean, no matter what process you use, there's always going to be bias and prejudice at some level. You try to minimize it, but it's never going to be perfect. So because we are human beings, and the ones who are reviewing are human beings, and that's where they want to go. But the only way to get there is by getting rid of it. Then it's perfect.
I think the question was subject everybody to the holistic review and not have some people who get in just based on grades and so forth.
Well, I mean, I think you want to getting every answer right on an SAT or LSAT means something. It means something. That's a skill, and you want to reward that, and you want that student who's smart, in terms of that way at the school. So I think it's good to have students who do well on the SATs, LSATs. There's some people who have great personality, no work habits, but you love talking to them for hours, and they have a place at the school because they're going to be good lawyers or judges, they'll be good attorneys. They'll persuade people, laws, but you don't want that to be all your class. And so I think the combination of picking some people because of numbers and some people because of other personality strengths is the way to go. I'm not saying people who have high scores are not going to have not personality. They may have all kinds of other things. But people who have great personalities aren't. Some of them either have or will develop great work habits. But our experience to date is a combination has been best.
Okay. So a couple more questions. I guess we'll try to get through these quickly if we can. Mike?
So my question is, do you believe that instituting a racially blind policy where you would admit both the race and the name of any applicant would be beneficial or worsen the problem?
Susan, do you have thoughts about that? You said a completely race-blind process, so you couldn't even tell by the name. Would you have to tell people they can't put any hints in their essay or something like that? Completely race-blind, but other things, other soft factors in addition to grades can be considered?
Economics also? Have economic information available?
What about socioeconomic background? Okay. I mean, Susan, I hear that as something you were essentially sort of advocating or saying that would be a reasonable way to go.
Yeah, I think statistically they were sort of looking at it. If we were to just look at socioeconomic factors instead of race, you could still come to the same racial diversity in a class. It would be pretty similar. And that's because, obviously, there are a lot of low-income black minorities and Hispanic minorities where I think that's one of the things that they were saying. I think that it's interesting if we were to take away race and do a completely race-blind process. I think that would actually be very interesting. I'm interested to hear how the dean would think about
that. And I think Judge Rodriguez wants to get in. Would that have worked for you? So you have been very candid. You said, I believe I was admitted because I have Latino heritage, and I might not have been admitted otherwise.
But that would work for me. I think we're substituting racial for socioeconomic. It's the same thing at the end of the day for the most part.
I disagree.
Of course. See, that's why you admitted it.
I mean, if you look, there are 10 times many white people who are poor than black people. Because there's a larger population. So if you start looking at poverty, you're going to get a lot more white students than black students. It's not it won't. It will produce a lot of poor white students in your class. Won't produce a lot of minorities per se.
I think I saw one more hand back
yes.
there.
I have a question.
And then this will probably have to be the last question.
So if half of, say, the law school is made up of people that get those perfect test scores, but then how do you determine that even? Because say if there's 50 spots for those perfect scores, but you get 500 applicants, like is there another layer? Because do you look at their undergrad institute? Like how do you make that determination?
Well, you mean perfect score from Harvard or perfect score from Podunk?
If
you get a perfect score from Podunk, but you didn't go to Harvard.
So in other words, the school,
SATs.
undergrad school is also considered. And another factor, I'm not meaning to do Frank's business, but I mean, not everybody you admit is going to come here. So I mean, we may admit a lot of people with perfect scores, but only a certain percentage of them are actually going to decide to come here as opposed to someplace else, right?
But I guess like Harvard, for instance, they're not going to accept every single person that has a perfect score. So how do they determine then the next layer? Like if they do have 10,000 people that apply that have a perfect score, then how do they whittle that down?
I suspect they do it out of 800 score from where? Regions of the country. The 800 perfect scores from Harvard wants to have the smartest students from each state.
I see.
Go to Harvard. The best students from Vermont, from Ohio, from Michigan, they want everybody in the school to know that the best student, the valedictorian, got into Harvard. So Harvard's going to accept all the people with perfect scores from all 50 states.
I think what Frank was describing earlier, where you sort of start by admitting people with perfect scores, I think he was talking about the law school experience, in part because we can't afford to not pay attention to numbers because of the U.S. news. As I understand it, at Harvard, that's not how it works. Academics, extracurricular, athletic, personal, all of those are equally considered for everybody. So I think Frank was describing a bit different process that maybe takes place at the law school, not necessarily at Harvard. So thank you for coming. This was a great turnout. I hope you agree this was a great panel. So thank you.